appeal in the matter of Planon Limited and Gilligan.
Yes, Ms. Baird.
My Lords, in my submissions, rather than separately follow the grounds of appeal, I'll address the key thematic issues in the appeal. First of all, the correct test of enforceability of the non-compete covenant at the interim stage. Secondly, the correct approach to be taken in this case, including the construction issue and then the reasonableness of the non-compete. And within that, I'll address the significance of the niche market. Then hardship as a discretionary consideration, which is the stage I say it ought to have been considered if at all, including the evidential issues that are raised in the appeal and the adequacy of damages. Then there is the new issue of delay. My Lords, I hope you have a further bundle sent to you yesterday, as well as the respondent's notice, and that I hope was a convenient way to save you having lots of different pieces of paper in relation to that point, and I ask to the extent that the respondent has permission to rely on that answer, that I also have like permission to rely on the materials there. I'm grateful.
And you were going to tell us that Mr. Shepherd is leading Mr. Lawrence on the
other
side.
I was indeed. Mr. Shepherd is leading Mr. Lawrence. I have been leading Mr. Green, who's unfortunately not able to attend today. So apologies.
Yes. Right.
Well, my Lord, the background you'll be familiar with from the papers. The date of the expiry of the restraint is midnight on the 6th of August. There are 4 months and a day left to, just under 4 months left to run on the covenant. So this is far from being an academic appeal. There are 23 other employees, I'm instructed, who are affected by a like non-compete covenant in their contracts with my client Planon. So this appeal has very real practical significance for my client. Going to the first question, the correct test to apply as to enforceability of the non-compete. The central question, well established in the authorities in my submission, does the covenant go no further than is reasonably necessary to protect the legitimate interests of the covenantee? We have that in authority from Herbert Morris and Saxelby, Office Angels, 2 cites that in the more modern context that was relied upon by the respondent. It's uncontroversial as between the parties here, as it was below. The TFS case, on which I relied below and do again here, gives guidance on how that test is to be adopted at the interim stage and woven in with the requirements of American cyanamide. And in my submission, TFS is right, not just as a matter of precedent, but also as a matter of logic. It's the central test and has been regarded as such since the decision was made. The case itself, my Lords, examines the authorities and identifies a sequence of questions that are to be asked. And turning to TFS, which is tab 1 of the bundle of authorities. My Lords, the key passage comes at paragraph 36 of the judgment of Mrs. Justice Cox, that in assessing reasonableness, there is essentially a 3-stage process to be undertaken. So first, the court must decide what the covenant means when properly construed. Construction is the first task for the court to undertake, therefore. Secondly, the court will consider whether former employers have shown on the evidence that they have legitimate business interests requiring protection. So the legitimate interests to be established is the second point. And then the third point of paragraph 38, once the existence of legitimate protectable interests has been established, the covenant must be shown to be no wider than is reasonably necessary for the protection of those interests. And then at paragraph 39 is set out what's come to be referred to as the fourth question in the TFS test, and that is the question of the court's discretion. Arguably, there's a prior question about the adequacy of damages. But that is the guidance given in TFS, and it is, in my submission, the logical sequence to be followed by the court. The covenant needs to be construed before it can be tested. The legitimate interests must be shown to exist. In this case, they were accepted by the respondent. The legitimate interests must be shown to exist before their reasonableness can be tested. And the third question being the essential question asked by the House of Lords in Herbert Morris.
Can I ask you, I think you described this as guidance for the interim stage and as interacting with American Cyanamide. But I thought this decision was given after a speedy trial.
My Lord, forgive me, that is right. Certainly, it is the test to be applied at the interim stage, because at the interim stage, the court is able to consider whether the covenant is enforceable. And so what TFS does in its 4 questions is set out the approach to be taken at trial in relation to the enforcement of an injunction. At the injunctive stage, at the interim stage, there'll then be that additional question about adequacy of damages.
But also, I mean, the normal American Cyanamide test is there a serious issue to be tried? And we know that in some cases that's modified because effectively you won't get to trial or it will be too late. So in that case, the court has to make at least some assessment of the validity of the covenant. But it's not the usual practice of the court to decide whether the claimant is right at an interim stage. The usual practice is to decide if the claimant has a good case, has an arguable case.
My Lord, yes, that's the threshold that has to be reached by the applicant at the injunctive stage.
Well, Ms. Byrne, you helpfully taken us to Mrs. Justice Cox's decision in TFS, and if one goes to paragraph 41, she cites Lord Justice Chadwick's judgment in Arbuthnot Fund Managers and Rawlings, where he says at paragraph 20, and I think this has been pretty well accepted for many years, unless the court is satisfied there are disputed facts which bear on the construction of the relevant contractual terms, and those facts can't be resolved without a trial, the court at the interlocutory stage is as well able to construe the relevant contractual terms as a court will be at a trial.
Yes,
I don't know whether either side is saying here that this is not such a case. Clearly, there isn't going to be a trial within the period of the covenant. Do you accept that this is Arbuthnot type of case that where the judge was and we are just as well able to work this out as a judge would be after a trial?
My Lord, yes. The nature of the issues put forward to justify the scope of the covenant in this case isn't such that the court at trial would be in a very much different position to the court at the interim stage.
Right.
My Lord, I say that as well as being the logical sequence, that departure from that sequence of questions risks the court falling in error, as with respect to the learned judge he did in this case, because of course if the clause isn't properly construed and understood, then the further analysis, the analysis of whether or not it goes wider than is reasonably necessary, is on an insecure foundation. My Lord, the sequence of questions is also relevant at the injunctive stage for the practical reason that many cases don't advance past that, in particular, because it is of importance for employers, and particularly in the situation that my client finds itself in, where there are other employees to whom this covenant applies, that the analysis of the court on enforceability, even if then at the discretionary stage the court isn't prepared to order an injunction, that is still of value to the applicant. It's still of value to the appellant in this case to know that its clause is enforceable, even if for some reason discretion is exercised against it. So that's the second reason, and it's an important reason, the declaratory function of the court in assessing the reasonableness and the enforceability of a restraint argued at the interim stage or even at trial. So, my lords, I say that the judge in this case did not follow the correct approach, and turning to the judgment, which is in the core bundle at tab 6, it is said by the respondent that the TFS test is adopted and is satisfied by the conclusion reached in paragraph 30 of his judgment. That's at page 62. My lords, it's right that in this paragraph the learned judge expresses his conclusion. That his preliminary assessment, he declines to uphold the non-compete. However, that conclusion can only be understood from the discussion that happens in the paragraphs preceding it. My lord, this section of the judgment begins a couple of pages back on page 60, paragraph 22. Is there a serious issue to be tried? And in particular on paragraph 26, the judge analyses the scope of the non-compete clause, and in the middle of the paragraph, it says, in those circumstances, it seems to me the burden will lie upon the claimant to demonstrate at trial a restriction of this kind is reasonable by reference to matters as they stood, either when the employment contract was entered into or at the time when it came to be amended. The point has been made to me, which I accept if one looks at clause 17.2 of the contract, one can see that the defendant would be entitled to be engaged or concerned in a business concern, provided that the duties of the employee or work shall relate solely to services or activities of a kind with which the employee was not concerned with a material extent in the 12 months before termination. So straight away, the focus of the learned judge in my submission is not on what is the restricted interest, how wide does it go, or how narrow is it, what is the extent of the confidential information and the customer connection.
Shall we look at the contract?
Yes, but rather just to finish the point of this paragraph, but rather the interests of the defendant and his position in relation in being able to find alternative employment. So the employment contract is further at page 75.
Just before
9.
you do that, you pointed out correctly that this section of the judgment is headed, is there a serious issue to be tried? The judge plainly answered that yes. He does that at 23 and again at 25. Do you need any more than that for the American assignment analysis? If you get to that stage, does it matter that the judge goes on to say, actually, I don't think it's that the prospects are that good?
Well, he didn't uphold the non-compete. He didn't enforce the injunction in relation to the non-compete covenant.
Yes, but that wasn't because he was satisfied there was no serious issue to be tried. It must have been some other reason.
Well, my lord, in my submission in relation to the non-compete, he doesn't consider that there's a serious issue to be tried. Plainly he does in relation to the other covenants and in relation to confidential information he was content to order relief, but not in relation to the non-compete covenant.
Well, he was making an assessment of your prospects of success on 17.1c. And he said at paragraph 30 that the prospects don't appear to him to be that good. You may say he's wrong in that evaluation, but he was entitled, surely, to form a view, I thought this was common ground, see Lansing Linda and the passage we've just looked at, cited by Mrs. Justice Cox from Arbuthnot, he's got to form some view of the merits.
My lord, yes.
Yeah,
That I accept entirely. There's no argument on the threshold to be applied in relation to Lansing Linda. But what I say is that had he followed the sequential approach in TFS, second of all, had he confined himself in the question on serious issue to be tried to analysing the legitimate business interests of the appellant and whether the clause, the covenant corresponded to that, rather than the interests of the respondent in wishing to obtain his preferred employment, the learned judge would have upheld the non-compete, or would have found that it satisfied the Lansing Linda threshold. He would have found that there was a serious issue to be tried. And the two errors, my submission that the judge fell into is, first of all, he didn't apply the test, so he didn't apply the Herbert Morris and Saxby formulation. But second of all, he focused on the interests of the respondent in obtaining employment rather than the business interests of the appellant, the legitimate business interests of the appellant, and what scope of restraint those interests would justify. Now, of course, to some extent, those two issues will cover the same subject matter, but they cover it in very different ways. So in order to satisfy the court that the covenant is reasonable, I'll take you to it in a moment, your lordships will want to see that it's not a blanket ban on competitive activity as soon as the respondent walks out of the door. Your lordships will want to see that it is moderated so that it is tailored to the legitimate interests that are sought to be protected. It's tailored to the sorts of duties that the respondent was performing, because it would go beyond my client's legitimate interests to stop him being, the example that I used below, being a receptionist, for example, in his new employer, doing a wholly non-competitive role in his new employer. But it would also go beyond, in my submission, our legitimate interests if the covenant stopped the respondent from doing competitive type of duties, that is sales duties, but in a non-competitive arena. So if he moved into an unrelated part of the software market, my client's in facilities management software, say he moved into accountancy software and was selling that, what possible claim could my client have to stop him from doing that? So that's the analysis that one would wish to see the judge embark on, rather than what the judge did in this case, in my submission, of saying, what would the clause allow him to do when he leaves, and what employment prospect does that give him?
All right, shall we look at the clause then?
My lord, yes. So tab is in the core bundle at tab 9, page 75. It's an excerpt from the contract of employment. And the clause itself begins on page 79. And at 17.1, in order to protect the confidential information, trade secrets and business connections of the company, and at C, the non-compete, for 12 months after termination, the employee covenants with the company that he shall not, for 12 months after termination, be involved in any capacity with any business concern which is or intends to be in competition with any restricted business. And, my lords, the definition of restricted business, you have to turn back to page 76. And it is those parts of the business of the company to which the employee was involved to a material extent in the 6 months before termination. And in my submission, what that means is facilities management software.
Well, that's critical, isn't it? And if this contract had been tailor-made, spelling out what it was that the departing employee would be prohibited from doing, it might be very different. But how does somebody know, looking at 17.1c and 17.2c, what it is that a departing employee must not do?
Well, my lord, in my submission, that is a matter of construction of the clause, and the respondent, any employee in his position, would know well what part of the business he had been working in, and indeed it's the only part of this particular business. So in terms of the objective understanding of the parties at the time the contract was made, this definition ought to pose no problem to anybody reading it.
17.1c, if it stood alone, plainly prohibits him from going to his new employers or any other competitor of Planon. And do you say that's reasonable, or it's only reasonable because of the carve-out in 17.2c?
It becomes even more reasonable with the carve-out in 17.
All right, well, what does 17.2c actually mean?
Well, 17.2c contains the carve-out. None of these restrictions in clause 17.1 shall prevent the employee from being engaged or concerned in any business concern, provided that the duties of the employee work shall relate solely to services or activities of a kind with which the employee was not concerned with to a material extent in the 12 months before termination. These are plain English words, and it would be readily apparent in my submission to the respondent or any reasonable employee that this meant duties of a sales manager, an account manager, and including in particular, in the respondent's case, business development. So this would leave him free to undertake non-competitive duties in a competitor firm. And it is the addition of 17.2c that makes this a yet more reasonable, in my submission, restriction.
Can you say again what services or activities of the kind which he was concerned were?
Yes.
Sales manager.
So an account manager, duty of his sales duties as an account manager, and including business development. In fact, I should say more specifically, product development.
Sorry, product development rather than business development.
My lady, yes.
He's not a technician. He's not developing the software. He's not a software engineer.
No, my lord. The duties were set out in the evidence of Lucian Camps given below and in the supplementary bundle at tab 3 is his witness statement. And but for reference, the key paragraphs are 10 and 12, describing his role as one of 2 account managers. The job description is a combination of account manager and account manager new business. And then at paragraph 12, the slightly unusual, possibly for a sales manager, the involvement in business development, really product development, because you'll see 5 lines down within that paragraph, the defendant worked on strategic account plans or roadmaps together with the claimant's customers based on the claimant's development roadmap for our new solutions, an opportunity for business development and upselling for new products, solutions and functionalities.
Yes.
So, my Lord, in my submission, it's a clear provision. It's one that would be readily understood by anybody in the respondent's position. And by virtue of those 2 carve-outs, first of all, in relation to restricted business, and then second of all, 17.2 in relation to the duties that are prohibited, the covenant then becomes reasonable. But in my submission, the judge took a different approach in his judgment.
Can I have it, just before you move on, just before, be sure I've understood that. You said there was nothing to stop the respondent from selling accounting software. That's not because of the carve-out in 17.2c, because it's the same type of activities.
Yes.
It's because of the interpretation to be given to restricted business in 17.1c, and you say that's confined to what you call facilities management software.
Yes.
So that's the scope of your client's business, and I think the evidence is that that's all your client does. Is that right?
Yes, indeed. Yes.
I'm not sure I understand what facilities management software is.
It's software to assist in managing premises. So I think, for example, they have clients who are universities. The software that underpins the running of the premises and the facilities on it.
I don't think that makes me much more informed.
Well, it says universities, hotels, public buildings, large office blocks.
Is it sort of keeping an eye on how often you need to paint the exterior, that sort of thing? Or what is it? Or paying for your electricity bills? I just don't understand what it actually does.
Yeah, my understanding is it's all of that.
All of that.
I'm sorry, forgive me. I'm told that it will extend to things like controlling the air conditioning, security access, all of the things that make the building function.
Right. And your client is not involved in selling accounting software or any other type of software, simply in selling facilities management software.
Indeed, yeah.
Thank you.
So yes, my submission is restricted business allows him to, the limitations of the scope of restricted business allows him to move into other parts of the software market.
Yep.
Then 17.2 allows him, even within the competitive
Go and work for a direct
realm,
competitor as long as he's not doing the same job.
Exactly. So that's the thing that this clause stops him doing. And of course, it's the exact thing that he went, we believe, went to ServiceNow to do. And in my submission, a non-compete covenant cannot get much more reduced than this non-compete covenant is.
Doing the same job in the same business.
Indeed.
And the law is you're not entitled to protect yourself against competition as such. You only to protect your legitimate interests.
Exactly.
But what are the legitimate interests?
Well, the legitimate interests are the confidential information and trade secrets of the employer. And again, there's evidence about the extensive access that Mr. Gilligan had to client information, customer requirements, as well as more strategic information. And then, of course, his business connections, his customer connections, his knowledge of the people to contact, that he had ready-made all of the tools to walk into, as he has done, a competitor.
But so does every employee of a certain seniority. He's a sales manager with 30 customers. So your clients are entitled to a covenant against dealing with the 30 customers. So that's no problem. Doesn't seem to be a case about poaching employees, but anyway, I think there's a covenant against that. So why are the claimants entitled to a covenant against competition?
Well, the question your lordship poses is, what is it about the legitimate business interests that justifies the extending of protection to include the non-compete as it's drafted? And might I just note that there's no drafting defect identified in the covenant itself. What then is the strength of the legitimate interest to justify that protection? And my lord, there are a number of rationales for needing to extend from the non-solicit and the non-dealing covenants that were upheld and enforced by the judge below to the non-compete covenant. The respondent replies by asking this question, asking a slightly different question on this same point, saying that that protection is adequate and that you don't need then to extend on to non-compete covenant. But in my submission, there are particular reasons why the non-compete is necessary here. First of all, it serves a policing function, and this is well acknowledged within the authorities. It allows policing, it allows the appellant comfort of knowing that the non-dealing and non-solicitation clauses will not be covertly breached, with all of the difficulties that are entailed in knowing exactly what is going on once an ex-employee joins a competitor firm in a competitor role. The second aspect of policing, the policing function, is that it polices indirect breaches as well as direct breaches. The ex-employee respondent may well provide information to other people within the competitor firm so that they are the ones who undertake the solicitation, they're the ones who close the deals, but they do it with the former employer's confidential information or using the business connection that have been formed by the departing employee during his or her time at the old employer. And those functions are acknowledged in the authorities, particularly in the two recent first instance decisions in EO and in Law by Design. The non-compete clause also circumvents some of the problems that are thrown up by the way in which non-solicit or non-deal covenants function. First of all, the problem that the new employer can be tipped off by the operation of those covenants. Because if the ex-employee is only subject to those covenants, and he says, oh, I'm sorry, I can't possibly undertake any solicitation of X, Y, and Z, then the new employer knows exactly that X, Y, and Z are on the old employer's books.
Well, of course they do, but that applies in every case.
My lord, no, because that information is sensitive. To know who the customers are, to know the combinations of customers, or to know the particular business that might be transacted or particular times at which business might be transacted. Those are confidential, sensitive matters that a company is entitled to protect.
Is it confidential that you have X as a customer?
May well be.
That seems, on the face of it, slightly surprising. If I was a competitor of yours, I'd simply ring up the relevant person at X and say, are you interested in our product? Who supplies your product at the moment? Are they not at liberty to tell me?
Well, yes, but you wouldn't have the information before you made the call. And that's the point, that this confidential information, these customer collections, give, in the springboard jurisdiction, it's described as a head start. And they save the competitor time and resource in having to do the cold calling, in having to do the research, in having to make the false hits. They allow the new company, the competitor company, to hone its approach, to know exactly who to target, when and how. And that's important, sensitive information.
But if that was it would justify covenant against competition in every case, and yet it's been settled law since 1916 that you can't obtain a covenant against competition as such.
My lord, it would justify a covenant against competition in every case where there were the legitimate interests in play and where the wording of the covenant went no wider than was reasonably necessary. And when that's satisfied, then yes, in my submission, the ex-employer, the old company, is entitled to a non-compete covenant if it can show that that protection is required.
All right. We don't need to look at anything else in the contract, do we?
My lord, no, but might I just close off the point, why is it that a non-compete is required? Why is that required to make the protection adequate to protect the legitimate interests? A non-compete also circumvents the problem of the ex-employee having to draw a line in his or her own head between what they know and can freely use and what information has the quality of confidence or has become a trade secret and so ought not to be used. So as well as protecting against the danger that the new employer is tipped off, the ex-employee doesn't also have the risk of placing him or herself in legal jeopardy because of that fine dividing line between confidential and non-confidential information.
You haven't helped yourself in your contract because you have a definition of confidential information which has space for listing certain things and nothing's listed. The point made by the judge. On page 75.
My lord, yes, and...
Including in particular. There's clearly a draft which is intended to focus the employee on particular information.
And doesn't.
There's nothing listed. Trade secrets. Tell me what you say is a trade secret, because I would have normally expected that to be some technical know-how, something like a formula or and so on, which wouldn't... But, I mean, as I said, he's not a software engineer. If he were, then he might have trade secrets, but he's a salesman.
Well, my lord, just on the contractual term, yes, of course, the contract is in the form it's in, but of course there are also the common law duties of confidentiality. In terms of what is and what isn't a trade secret, in the evidence that was provided to the court below and is here now, a number of types of information and types of document or database are discussed. So if I can go through those, and I'm reading through the witness statement supplementary bundle tab 7, paragraph 17 onwards. So paragraph 17, the database Salesforce, that's the customer relationship management software database, and that is a database containing all of the customer's details, and it is the combination, it's the assembly of that information that in particular gives it the character of confidence and of trade secrets, because although items of information may well be within the public domain, the fact that they have been assembled, as customers for facilities management software with, for example, contact details and appropriate phone numbers, that is what gives it.
You don't make a case, do you, that he has taken away printed copies or soft copies of this information. That's not an allegation you make.
No.
He says, I can't possibly carry all this information in my head, which seems to me prima facie credible.
Well, in my submission, with 30 accounts being handled, he will have significant amounts of information in his head. And it will be easy for that information to be recalled as he works on the ground.
Yes, but that is so in every case.
And
You're saying that every sales manager, every accounts manager, up and down the land, because he will remember who his, in this case, rather small number of customers are, 30 customers, and he'll remember that at that one, the person you ring and speak to is Fred, and at that one it's Sophie or whoever. That for that reason he can be stopped from competing for 12 months. Can't possibly be.
my lord, yes, I can come to that point in a moment. I think just to be clear, we don't entirely know what information he may or may not have taken with him. We're not able to make a clear allegation, but of course we don't know and we won't know until disclosure is undertaken at a later stage. My lord, this relates to the point that I made a little earlier, which is that if the formulation in Herbert Morris and Saxelby is satisfied, that is, if there are legitimate business interests which are of sufficient strength to justify the restraint that's contended for by the ex-employer, then the answer is yes.
Yes, well, that begs the question, doesn't it? All right.
Well,
Do you want to go on to the law then?
Well, my lord, yes, but the sorts of information, the sorts of client details are both highly sensitive, highly important, and highly portable in a modern age. It's very easy to walk out of the door with the substance of the business in your mobile phone. And so the
Now,
ubiquity of these
you've got to be
clauses.
careful about this, Miss Bone. As Lord Justice Nugee put to you, this is not a case where you have evidence that the defendant took away confidential information in portable form. If a defendant does, then there are plenty of cases about what can be done to restrain him from making use of that information. But I don't think you're saying that, are you? You are saying that, as is no doubt true, there will be quite a lot that he carries in his head.
My lord, yes. And coupled with the business connections that he will have formed over the course of his employment as one of two account managers, that is, in my submission, a valuable and legitimate interest to be protected.
Can I go back to my Lord's question? Suppose Mr. Gilligan knows that the person he dealt with at the University of Nottingham was Mr. Fred Jones. Is that a trade secret? Is it confidential information? What is it?
In my submission, it is because of what it links to, because of what is necessarily being stated in the very slender statement that your lordship makes. I knew Fred Jones at the University of Nottingham actually means we provided facilities management software to him. There is that need. Our business was able to satisfy it. This was the approximate date. And then it's very likely, in my submission, that an ex-employee would have some recall of the terms, might have some recall of a sticky point in negotiations or a very peculiar requirement that client had.
And that all,
So
it goes in the basket marked confidential information.
Well, yes.
I'm still a bit hesitant about describing it as a trade secret, which seems to me to be a rather different type of information, but it may not matter for your purposes which it is, if it's a legitimate thing to be protected.
Well, indeed, on either side of the line, I say that it is a legitimate interest to be protected.
Thank you.
Right. Where do we go next?
Well, my lord, I mentioned the two cases of Year and law by design as addressing, in particular, the question of why a non-compete is justified. In addition, and Year, which is tab 3 of the bundle of authorities. This is a case in the mail and parcel delivery services industry, where there was a suite of covenants applying to the defendant, who was head of client services and a senior member of the management team. And at paragraph 31 of the judgment of Mr. Justice Saini, there is discussion of the background to, here it's a non-dealing covenant being discussed. Beckett Investment Management Group and Hall cited the narrower and more specialist the market, the more likely it is that a non-dealing covenant will be upheld, given that clients in those circumstances naturally gravitate to the ex-employee who opens up a new competing company in such a case. And then paragraph 32, the difficulties of policing confidentiality clauses and non-solicitation clauses. The judge notes are one of the reasons why the court will uphold more stringent non-dealing clauses or even non-compete clauses. And then the Thomas Farr and the Landmark Brickwork cases are cited, so the policing function is set out there. My lord, this is echoed in the very recent case of law by design, which is at the next tab 4 of your bundle. This is a case of solicitors, covenants against a solicitor. And I noted, indeed, in my supplemental skeleton that the covenant in this case is eerily similar in the way that it's drafted to the non-compete before the court now. So the covenant itself is at paragraph 28 of the judgment, and takes a very similar form. And paragraph 28 begins the SA, that's the service agreement, provides as follows. And it's 19.1D is the non-compete. For 12 months after termination, be involved in any capacity with any business concern which is or intends to be in competition with any restricted business. That's our 17.1 in effect. And then 19.2, none of the restrictions in clause 19.1 shall prevent the employee from, and then over the page is C, being engaged or concerned in any business concern, provided that the employee's duties or work shall relate solely to services or activities of a kind with which the employee was not concerned in 12 months before termination. So that's the non-compete in the law by design case. And the justifications for the non-competition clauses are expressly noted by the learned judge at paragraph 64. Non-competition restrictions are commonly used and upheld where lesser forms of restriction would be inadequate or difficult to police.
Sorry, what is the business of Law by Design Limited?
It's a law firm, my lord.
What, really? I mean, of course, it is. But the claimants weren't seeking an injunction to stop Nugee from having anything to do with legal practice for a year, were they?
Well, they were seeking to enforce, and they did enforce the non-compete covenant. So we can see right at the beginning of the judgment, the judge begins, it all went well for a number of years, and then describes how a small law firm, boutique firm, was formed, but then Ms. Ali handed in her resignation, explaining that she wanted to join a larger firm as a partner, and in this claim, the firm says the post-termination clauses contained in the agreements restrict her ability to do so for a period of 12 months.
I think the answer to my Lord's question is at paragraph 73, where he looks at the nature of the work undertaken by law by design, and he says he has to determine what the business of LBD was in order to establish whether a business is in competition with it. So it's clearly not any legal practice.
Might I assist the court? At paragraph 43, there was a prior undertaking that was provided that seems to have limited the services to an NHS entity located in the northwest. So it's a specific area of law, employment law, and the NHS, it seems to be.
Also, I haven't looked at this case properly, but is it an employee case or a shareholder case?
Well, she was a partner in the firm, so it's a
You're a partner,
Yeah.
a partnership case.
Well, it's a company. So she was presumably a shareholder.
the covenant in the service agreement was upheld, but the covenant in the shareholder agreement was not upheld.
Oh, she,
So was she a salary partner?
if you run a law practice through a limited company, the lawyers who are working for it are likely to be directors, solicitors, shareholders, not likely to be partners as such. I think she was an employee, was she not?
That's my understanding, my lord. Yes, indeed, it's the contract of employment.
Sorry, Mr. Shepherd, I didn't catch the paragraph reference that you gave a moment ago. To the
It
undertaking.
was 43
43, thank you.
on page 62 of that one.
Thank you very much.
Right. What do we get from Mr. Beer QC's judgment in this case?
Paragraph 64, my lord, the justifications for non-competition clauses are set out and discussed and reflect the submissions that I've made to you already as to the policing function of the clause, the function of avoiding the difficulty of going over the page to paragraph 66, the difficulty of having to distinguish between and police the boundary between confidential and non-confidential information.
Yes, he helpfully refers to Lord Justice Toulson and Thomas and Farr. employee is exposed to information of the kind capable of protection beyond the terms of the contract, the term of the contract, i.e. trade secrets or other information of equivalent confidentiality, and so on. Right. Mazzali is described as a director of the claimant company. Right. Which part of the judgment should we go to next?
And then, my lord, at paragraph 93, in considering whether the clause goes no wider than reasonably necessary, the judge reads both parts of clause 19, so 19.1d read with the provisos to it, and holds that it operates the way in which it operates and legitimate interests that properly require protection. It is an uncomplicated conclusion to reach that this covenant extended no wider than was reasonably necessary. So taking into account both aspects of the clause, the clear and easy conclusion of the court in that case, and I say so also should be in this case, it is that it goes no further than is reasonably necessary. And to the extent that it's noted as a point of distinction that Mazzali may have been senior, may have been akin to a business owner, that of course may have fortified the legitimate interests and their need for protection in that case. But the reverse isn't true, that without that level of seniority, there isn't a sufficiently strong legitimate interest in the present case. And in fact, the role that the respondent did, the access to information, the autonomy that he had in carrying out his role, is significant in informing what the legitimate interests are. Seniority does not necessarily, of itself, give rise to a sufficiently strong legitimate protected interest. But in this case, as one of only 2 account managers with 30 accounts being handled, I say that his position in the hierarchy is really irrelevant. And what matters is his connection to the interests sought to be protected. And I'm reminded too that unusual feature of being involved in product development, and in the witness statement of Lucian Camps, he explains that the respondent, part of the respondent's role was in dialogue with customers that he had that connection with to see how they experienced the products and so refine and hone them. That was also an important part of his role that gave rise to, even in the absence of a formal position of seniority, a significant position in the business and in the future development of the business. My Lord, it might be convenient now to address you briefly on the niche market point, which my submission wasn't considered, taken into account by the judge, but is a yet further reason why this covenant is necessary to protect Planon's legitimate interests. That the niche nature of the market means that ServiceNow's entry into that market is a real threat. And whereas customers may have had a loyal relationship with Planon, there is the risk that they may now turn to the obvious new rival in the arena. And so the niche nature of the market, which is evidenced by Mr. Camps, in my submission provides further support for the non-competition covenant.
Is that a theme to be found in the reported cases?
Yes, my lord, it's in YEO, back at tab 3, and paragraphs 31 and 32. Which we went to a moment ago. So Beckett Investment and Hall, the narrower and more specialist the market, the more likely it is that a non-dealing covenant will be upheld.
Yes.
And I say that that logic applies also to a non-competition covenant. The narrower market, the more likely it is that relationships of loyalty have built up, and the more likely it is that when a new entrant comes along, there is an obvious alternative to turn to. And so a keener competition. And in that circumstance, the edge that the ex-employee will have in terms of information and connection becomes yet more valuable and so yet more important to protect. If I can turn back to the judgment before I then go to the two authorities that the respondent relies upon to say that the judge undertook the correct approach to the Stenhouse case and the Harcus Sinclair case. If I can go to the judgment to look at the exercise that was in fact undertaken by the learned judge. In the core bundle at tab 6 and key paragraphs of 27 through to 30, or 26 through to 30. And I start at 26 because 5 lines from the bottom of that paragraph, the judge refers to clause 17.2, so that second delimitation, the second qualifier in the non-compete. And he says, I accept, if one looks at clause 17.2, one can see that the defendant would be entitled to be engaged or concerned in a business concern, provided that the duties of the employer are not against the terms of 17.2. The learned judge then goes on at paragraph 27 to consider what the ambit of a new employment would be for the respondent within the terms of the covenant. And first of all, he considers my submission, it would be perfectly possible for the defendant to go off and work in other areas of the software market. He says that strikes me as a somewhat unrealistic submission. And then proceeds into a consideration from the respondent's point of view of the possibility or difficulty of obtaining employment, and comes at the end of the paragraph to extrapolate that. He says the effect of 17.1c is to operate as a complete ban on the defendant working in this area of the software market for a period of 12 months. That could quite easily translate into a period of 12 months unemployment. And my lord, having gone through the correct approach, the analysis of legitimate business interests and how I say the key test in Morris and Saxby is fulfilled in this case, one can see in my respectful submission how the learned judge has fallen into error here, because he regards it from the point of view of the respondent's ability to obtain new work, rather than whether the restrictions on what work he could or couldn't do would be justified as at the time that the contract is entered into by the parties. At some point in this paragraph, the judge stops looking at clause 17.2 and appears, in my submission, to confine himself to considering the clause without that qualifier and considering the clause as 17.1c only. So not recognising that there is that yet narrower delineation of the prohibition that the respondent is under. And in my submission, these are the key errors that the judge makes. He makes a further error to then extrapolate from can't work in the software market to this could be a period of unemployment. And I'll go into that a bit further on in my submissions. But here we see the judge falling into error in my respectful submission, not applying the test of analysing the legitimate business interests, really the focus of the appellant and the appellant's perspective, but instead looking at the respondent's prospect of obtaining employment. And it's said by my own friends in their skeleton, rely, as I said, on Stenhouse, Australia, and also Harker Sinclair in relation to this point. The proposition that's relied upon from Stenhouse, the skeleton argument is core bundle tab 12, and the proposition relied upon is at paragraph 23 of the skeleton. When assessing the reasonableness of restrictive covenant, the employer's interest in business protection is to be balanced against the employee's ability to earn a living in their particular area of expertise and experience. My lords, I don't, in my submission, that is not the correct test to be applied. That is a misstatement. And whilst I accept that considerations of hardship can come at the discretionary stage, in considering the enforceability of the covenant and the serious issue to be tried, that's not the correct balance of interests. The employee's interests are balanced by the Herbert Morris and Saxby formula, by ensuring that protection goes no further than is reasonably necessary. If we turn to Stenhouse and to the paragraph that my learned friend relies upon, page, so that is tab 6 of the authorities bundle, and page 400. First of all, at 400D, the Lord Wilberforce sets out the Morris Saxby formulation. The only question is whether the appellant can show they impose no greater restraint than reasonably necessary for its protection. And then the paragraph that follows that, upon which my learned friend places reliance, it is in truth the paragraph that addresses the rationale, the public policy rationale, rather than setting out the test itself. And Wilberforce says, the accepted proposition that an employer is not entitled to protection from mere competition by a former employee means that the employee is entitled to use to the full any personal skill or experience, even if this has been acquired in the service of his employer. It is this in freedom to use to the full a man's improving ability and talents which lies at the root of the policy of law regarding this type of restraint. And pausing there, my lords note that the focus is not on the ability to earn money and to avoid hardship. The focus is on freedom of competition. The focus is on a free arena in which a person can ply their trade. And that's why it's public policy. Going on then, the employer's claim for protection must be based upon the identification of some advantage or asset inherent in the business which can properly be regarded as, in a general sense, his property. And then towards the end of the paragraph, while it may be true an employee is entitled and is to be encouraged to build up his own qualities of skill and experience, it's equally his duty to develop and improve his employer's business for the benefit of his employer. These two obligations interlock during his employment. After its termination, they diverge and mark the boundary between what the employee may take with him and what he may legitimately be asked to leave behind to his employers. So the passage that's relied upon does not, in my submission, support a contention that there is a balancing act to be done between the business protection interest and the ability to earn a living. And considering the context of this case, where what is being said by the respondent is, at the time that the injunction was issued, at the time that the injunction application was issued, if the non-compete had been enforced against me, I would have been unable to continue work at ServiceNow. We don't know the full truth of that statement. That's what he says. I would have been unable to work at ServiceNow, and I might not have got any other job. That can't be a proposition that Stenhouse or any other case in my submission bears out. Partly because it's not part of the test, it's not part of the Herbert Morrison-Saxby formulation, but it also runs contrary to the principle that the covenant has to be construed at the date that it's entered into, so it's at the start of the contract, rather than whatever vagaries in the ex-employee's financial position are alive at the point that either the contract is terminated or the injunction application is issued. But certainly the Stenhouse case doesn't provide the support for which my learned friend contends. And if you go forwards in the judge's and the court's analysis, you'll see a very conventional analysis of the scope of the business, and even in the recitation of the facts in the headnote and in the submissions, you won't see any suggestion of, Mr. Stenhouse having financial needs or being in any position of hardship, or there being any relevance to that type of submission. That simply wasn't made. The second authority that my learned friends rely on, that I want to turn to, is Harcus Sinclair. And what my learned friends say, again, the core bundle, tab 12, skeleton argument, at paragraph 26, is that they cite Harcus Sinclair. It is permissible, for a judge to refer to subsequent events where they are related back to the intention of the parties or what was in contemplation at the time the contract was made, as long as the reasonableness of the covenant is assessed at the time it was entered into. And if we look at Harcus Sinclair, that proposition may itself be correct, but it's not in my submission correct in the way that the respondent seeks to use it, seeks to deploy it in this case. The Harcus Sinclair case is at tab 7 of the authorities bundle. And it's an unusual set of facts. There was the parties entered into an agreement contemplating, for the sharing of information, contemplating that they would then enter into a second agreement for financing conduct of group litigation. And the first agreement was a non-disclosure agreement. And turning to...
Is this right? The non-compete undertaking was what I would call a sort of non-dealing clause. That the undertaking was not to act for any other group of complainants in the contemplated group litigation against a car manufacturer.
Yes. And my lord, what became the issue in this case was whether the legitimate interest which the learned judge held justified that clause, whether that legitimate interest could be informed by the intended second agreement. So whether the legitimate interest that is thought to be protected by one contract can be justified by matters that are out with the contract. And simply the answer was yes, it can be. And the fact that the second agreement wasn't made at the time that the first agreement was made wasn't fatal, because it was in the reasonable contemplation of the parties. And paragraph 47 the
Same judge as in this case. First instance.
yes. In that case, paragraph 47, it's noted that the facts contain a novel situation for the application of the doctrine. So there's no challenge to the Herbert Morrison Saxby formulation. It's an application of it, described as a non-compete undertaking given by one law firm to another in relation to a group litigation claim, and then turning forwards to 57, the judge's view was your lawyers had legitimate interest in protecting its own proposed group claim from Harcus Sinclair setting up a rival group claim. Those legitimate interests flowed from the intended process of informal collaboration, which would be embarked upon consequent on entry into the NDA. And then the discussion picked up at paragraph 63. Plainly, there is no need for the legitimate interest to be spelt out or referred to in the contract. And then further down the paragraph at D, the question we are asking is not whether a legitimate interest has to be mentioned in the contract or must flow from the contract, taken in isolation from other contracts. Rather, the question is whether, in determining the promisee's legitimate interests, one can take into account not only the contractual obligations of the parties, but also their non-contractual intentions or what they contemplated as a consequence of entering into the contract. And at 64, it's relevant to note, no doubt it will be rare for this question to arise. In my submission, that must be right. It's binding authority, but it doesn't apply in this case to assist the respondent in my submission. What the respondent doesn't identify, perhaps will in oral submissions, is what it was that was said to be in the reasonable contemplation of the parties at the time the contract was entered into. What is it that the Harcus Sinclair principle would bite on in this case? Part of the reason why I say the TFS guidance is so helpful and ought to be followed is because when one comes to the discretionary stage and comes to considering exceptional issues like hardship, the court will have already determined that there is a serious question to be tried. The court will have already determined that the covenants are on the interim threshold test likely to be enforceable. And that will then imply that the respondent seeking to avail himself of the discretion is likely to be a contract breaker. So the question then being considered is a very different one. And the question is, well, in what what is it that was in the contemplation of the parties that would stop the respondent as a contract breaker from being able to be restrained by injunctive relief? What is it that would stop him, if he broke the clause, from then not being liable to the clause? What is it? Because, of course, this is a case where it was a voluntary departure. The respondent is the author of the circumstances. He's chosen to go to a competitor. What on earth could have been in the contemplation of the parties, even subjectively, let alone on an objective, reasonable analysis, that would somehow strip away the protection of the non-competition clause?
Can I go back and pick you up on something you said? You said by the time you come to this stage, you will have already determined there's a serious issue to be tried, and therefore the clause is likely to be enforceable and he's likely to be a contract breaker. That rather suggests that you only get over the serious issue to be tried threshold if you have the better of the argument.
Well, I'm being loose with my language.
Yes.
I entirely accept on the Lansing-Linder threshold, which is some assessment of the merits.
American Sandman says you just need to get a serious issue to be tried. And all that does is cut out the case where it's frivolous or vexatious or there's a knockout blow of some sort. Lansing-Linder says in a case like this, you go further. You make some assessment of the merits. And the case my lord referred to, Lord Justice Chadwick, says if you can usually decide questions of construction at the introductory stage, it doesn't mean you can decide questions of reasonableness and what the interests are. That depends on the evidence. May or may not be in dispute. But you make some assessment. But you don't have to reach the stage of being satisfied it's more likely than not that the claimant's going to win, do you?
Lordship is entirely right, and I should have said potential contract breaker, I think, rather than a likely contract breaker. Forgive me.
Yeah.
But the point still holds. If the hardship that the respondent relies upon only comes to pass if the non-compete is enforced against him, why on earth would it have been in the contemplation of the parties that in that circumstance somehow he ought to be released from the clause?
It's common ground, isn't it, that the time at which the reasonableness of these clauses has to be considered was the time at which the amended contract was signed, I think. And probably doesn't make a difference as between the original contract and the amended contract. But at that point, the latest contract of employment, you have to look at the reasonableness or otherwise of the clause. Then, without the wisdom of hindsight as to what happened.
Yes, indeed.
I think that's common ground.
Yes, indeed. And of course, in doing that, you are, in my submission, to look at the ordinary anticipated progression of the contract.
Yes.
Well, I think in the Harker-Sinclair case, there's a quotation from something Lord Diplock says, which says exactly that.
Gledhow and
yes.
Delaney.
Has to be determined in the light of what may happen under the agreement.
Yes.
Page
Yes,
66.
64.
Yes.
Of course, in the first week of a contract of employment, the employee usually has no customer connection and no access to trade secrets or anything else. But it is anticipated that as time goes on, he or she will acquire them.
Indeed. And in that circumstance, so if the employee on the first day was to meet with some unfortunate accident and not even attend work at all, in my submission, that would not stop the non-compete being prima facie enforceable, but it's a pretty powerful factor at the discretionary stage.
On the question of the judge's paragraph 27 and the fact that the financial consequences to the defendant of 12-month non-compete, come to this, that damages would not be an adequate remedy for either side. I can't think of an employment covenant case in which it's ever been held that damages would be an adequate remedy. It isn't for the company if an injunction is wrongly refused. It isn't for the employee if an injunction is wrongly granted. The significance of the drastic nature of the covenant, if that is what it is whether it goes further than what is reasonably necessary to protect the employer's interests. It's not a question of adequacy of damages. It's a question whether it goes further than reasonably necessary.
Well, yes.
And the wider the scope of what is prohibited, the more drastic it is. The longer the duration, the more drastic it is. But that's the question which financial consequences for the defendant illuminate. It's not that he would lose so much money. It's whether the covenant is more drastic than it needs to be, applying Herbert Morris and Saxon.
My lord, exactly. In terms of the serious issue to be tried, in terms of the enforceability of the covenant, adequacy of damages is not part of the consideration, but it very much is in terms of considering what is the appropriate relief to be ordered.
Yes.
My lord, perhaps it's convenient now to address you on adequacy of damages, because in my submission I say that it is possible for the employee, even if the covenant is wrongly enforced, for damages to compensate. And damages, in my submission, will be readily able to be assessed because they're the damages for being out of employment. And of course, it may be said, well, that's not just the loss of earnings. No, it may not be. Loss of congeniality of employment, loss of promotion prospects, and some compounding. But that's something that is commonly assessed. It's commonly assessed in the employment tribunal on a weekly basis, where someone has lost their job. So in my submission, as long as the ex-employer is good for the cross-undertaking of damages, then damages will ordinarily be an adequate remedy for the employee.
Really?
My lord, yes.
Oh.
Is there any authority
Yes.
on that?
Yes, my lord, the two cases that I would refer to are Yeo and Underwriting and Newell. So Yeo, which we've been to already, is at tab 3 of the authorities bundle. Paragraph 36 addresses adequacy of damages, and indeed it refers to the Newell case as well. So the judge, first of all, agrees damages would not adequately compensate claimants for the loss they would suffer. Damages would be very difficult to quantify. Mr. Plant sets out it has taken years for the claimants to create their reputation on market-leading services. But then in employment competition cases, damages are rarely an adequate remedy. Then 37D is, however, protected by the significant cross-undertaking offered by the claimant, and there is no evidential basis to question its value. In that case, damages were considered adequate from the employee's perspective. Going then to underwriting.
Well, before you leave that at 39, it was argued there that the injunction would effectively stop him from working, which is what is argued here. And the judge says, well, there wasn't any evidence to that effect.
Yes.
So that suggests, and certainly to my mind, if the effect of an injunction is to keep someone out of the workforce entirely for 12 months, that imposes an immediate hardship. People have mortgage payments to make and so on. This particular defendant is supporting his wife's family in Brazil. Simply saying, oh, well, it's all right because you recover under the cross-undertaking in 12 months' time is not an answer to that sort of hardship. Is it?
Well, my lord, an answer to what sort of hardship in my submission?
Well, if it is the case that the practical effect of an injunction is to keep the defendant out of employment for 12 months, then that imposes immediate financial difficulties on the defendant, which simply recovering under a cross undertaking in a year's time doesn't completely adequately satisfy.
I'd make 3 points in answer to that. First of all, that the respondent is the author of that situation. The respondent has chosen to depart and to go to a competitor and to undertake competitive duties there, knowing that he has a non-compete covenant in his contract of employment.
Sorry,
and
this is
knowing
rather important. I must write this down as Ben. Damages would be an adequate remedy because the company is good for the cross undertaking. The defendant is the author of the situation. Right. Yes.
he has had the opportunity, if he wished, because this isn't a case where he's been pushed out, it's a case where he's chosen to leave. He has had the opportunity to prepare for that departure, and he has had the opportunity to choose what his departure is and where he goes to. And this touches to some extent on the submissions I'd make on hardship as a discretionary factor as well. But because what's really being asked by the respondent is, in the face of an ostensibly enforceable covenant, the appellant should bear the risk of his gamble. The respondent is saying, well, I tried to go to, or I wanted to go to, a competitor, undertake competitive duties. If you come and enforce your clause against me, then I'll be out of a job and I'll have to look elsewhere. Well, yes, but that's because he's done something that is in breach of his, or in potential breach of the contract of employment, and a contract that he well knew was there. So what the respondent is really asking is to be protected from a gamble he has run. A departure that he has determined himself upon, that he has planned, that he has had the opportunity also to plan the potential financial implications of that departure.
Yes, right. Just going back to Mr. Justice Saini's paragraph 37 seems startling to me. Is there any other case in which it's been held that, provided the employer company seeking the injunction is good for the money, which this one clearly is, then you never get to cyanamide's stage 3 because they can afford to pay him, he can't afford to pay them, therefore they win.
Before I come to that, can I just set out...
Is there any other case in which that is said?
I'll take you in a moment to underwriting and Newell, but if I can just set out the second and third points in response to Lord Justice Nugee's questions. So the first point is that he is the author of the situation in which he then finds himself once the covenant is sought to be enforced by way of injunction. Second of all, in response to my lord's questions, I said, well, what is the hardship? There has been, in this case, in my submission, an impermissible acceptance of entirely speculative comments in the respondent's witness evidence that he would not be able to find any employment at all, that if he's not able to do the job that he has at ServiceNow, he would therefore be in a 12-month period of unemployment. And in my submission, that doesn't follow as a matter of logic, but it certainly cannot follow without evidence to support it. And there's, on that, the evidence is wholly absent. We simply don't have anything near the sort of evidence that the court ought in my submission to require to say, cannot do any other job at ServiceNow. in particular, we don't have his contract of employment to know whether some of his duties were non-competitive and were the type of duties that would still have been permitted. There's nothing to suggest that he couldn't have got employment in some other part of the software market. And I mentioned accountancy software earlier in my submissions because the respondent had experience, I think it's a few years ago admittedly, but he had experience in other parts of the software market before going into facilities management sector. So it doesn't follow saying the covenant prohibits competitive activity within a competitor. It doesn't follow from that there's going to be a period of unemployment or any hardship at all. In fact, part of the court's rationale in seeking the delimitations, in particular seeking the delimitations around the non-competitive activities, that second delimitation, non-competitive activities within the competitor, is in order to permit those non-competitive duties to be carried out. And typically, an ex-employee may go into a competitor firm and use the period of restraint to bed in and be doing inoffensive activities, compliance and other back office types of activity. So there are possibilities in abundance. And of course, there's a duty of mitigation. There's a positive duty on the respondent and any ex-employee to seek out ways of earning his living, even with the imposition of a non-compete covenant. And the third point is, even if there's a period of unemployment, it still doesn't follow from that there's hardship. And the court ought, and it's entirely possible, even on the urgent interim basis, it's entirely possible for a respondent to provide some evidence of means or lack of means that truly does give rise to hardship. Because it should only be in exceptional circumstances in my submission that hardship is permitted to override, at the discretionary stage, permitted to override an otherwise enforceable non-compete.
Right, you're going to show us another decision that supports Justice Saini's paragraph 37.
Yes, the Newell case, which is the final authority behind tab 17.
I see. Same claimant's counsel.
I'm sorry?
Same claimant's counsel.
Yes.
Right, this is 6 years earlier. His Honour Judge Seymour.
And it's paragraph 31. It is not usually the case in cases of this type, the damage would be an adequate remedy. And then and so yes, so the judge there is not expressly directing himself in that paragraph to the employee's position. He goes on at paragraph 33 to then to consider the balance of convenience, and says it would be an unusual case in which a former employer was seeking to enforce against former employees' restrictive covenants and contract, in which the court came to the conclusion that the balance of convenience favoured the employees. The reason is, this is my point in relation to the hardship and the exercise of discretion, the reason is that the court to have got to the stage of considering the balance at all, it must have reached the conclusions, as I have, that insofar as there were disputes about it between the parties, there were serious questions to be tried in relation to the allegations of the claimant, and that damages would not be an adequate remedy in the event that injunctions were not granted. And then paragraph 37 at the bottom of the paragraph makes the point that I've echoed in my submissions, I am afraid it's a case of Mr. Newell having to take the consequences of his gamble, that it was worth investing the funds which he did invest and assuming the commitments which he did assume in anticipation of being able to compete with the claimant.
It might be said that this is a case in which the judge has simply overlooked the requirement to consider whether or not damages would be an adequate remedy for the defendant.
My lady, in my submission, plainly the judge saw the adequacy of damages as being a point to assess in relation to the employer and there not being an issue that required to be assessed in relation to the employee. So for those reasons, I say that damages an adequate remedy in this case, as they will be in many cases for many ex-employees. So if I can turn then to the discretionary stage and considerations of hardship at that stage, and perhaps the words of Mr. Justice Seymour, paragraph 33 of Newell, in informing that by the time that the court comes to this, it has already made a decision that there's a serious issue to be tried, and it should only be in exceptional circumstances where hardship can be a factor mitigating against the grant of injunctive relief at the interim stage. There is a wide discretion open to the court, but in my submission, it's not open-ended. I've set out in my skeleton that the ordinary expectation at trial is that an injunction should be granted, and in my submission, there should be an expectation that if the requirements of the tests are fulfilled at the interim stage, there should also be an expectation.
I don't think that follows. At trial, the judge will have decided that the covenant is enforceable or not. That's the function of the trial. If he decides it's enforceable, then, as you say, normally an injunction will follow, because that's Doherty and Allman, and it's not absolute, but the normal remedy for breach of a negative contractual obligation is an injunction. But at the interlocutory stage, the whole purpose of American Signing is you aren't deciding who's going to win at trial. You're looking at what regime should hold the ring pending trial. And even under Lansing Linda and the other authorities we've looked at, the court at an interlocutory stage is not deciding who's going to win. It's not deciding the covenant's enforceable. It's deciding what shall we do in the meantime. And that's where the damages adequate on one side, are damages adequate on the other side. And then Lord Diplock says, you look at the balance of convenience. And speaking for myself, I'm not at all convinced by the approach of his Honour Judge Seymour and Newell by saying that once you get to that stage, you really ordinarily get an injunction. It must depend on a whole range of factors, must it not?
Well, my lords, all that is right in my submission, but where the tests are fulfilled on a serious issue, where the applicant can make out that damages are inadequate for it, but adequate for the ex-employee, then turning to the balance of convenience, the starting point should be that an injunction is the ordinary interim remedy, unless there's a reason for the court to exercise its discretion against the grant of relief.
But that supposes that the court has found definitive that the covenant is enforceable. And I've never before heard of Doherty and Allman being cited as an authority for the proposition that at the interlocutory stage, a negative covenant should be enforced against an employee as of a course. I mean, it's a completely different area of the law, and you cite a number of cases. For example, Dyson and Pelleray, reported as DMP, in which the question was, what was the remedy once the covenant had been found to be enforceable? If you had a finding at trial or by concession that these covenants go no further than reasonably necessary to protect the employer's legitimate interest. If, then it's right that normally, not always, but normally, the correct remedy is an injunction. But why does that help us?
Well, my lord, the injunctive stage is considered again in the Year case, tab 3 of the bundle of authorities. I think I've cited in my skeleton, absent strong countervailing reasons, Mr. Justice Laing says at paragraph 38, the balance of convenience justifies an injunction. And
sorry. Yes, well, that's on the balance of convenience, but it's not. He's not saying because of Doherty and Allman that the claimants get an injunction as of right.
I appreciate that. In my submission, it is a correct statement that absent strong countervailing reasons, ordinarily the balance of convenience justifies an injunction. That is that where an injunction application is in sight or where it's made, the parties ought, in correspondence or in their arguments, to identify what strong countervailing reason there is against the grant of an injunction. The court ought to have a strong countervailing reason to exercise its discretion against the grant of injunction at the interim stage. The reason for that is because in part, even where there's an expedited trial, the injunction is the primary remedy. It's the remedy that really matters to the injunctive applicant. And just as it was said, well, it's unfair to the ex-employee to be told in 12 months' time there'll be a cross-undertaking in damages if things has gone wrong. Well, so it's also unsatisfactory to the applicant to have to go through the interim period and wait until trial for the remedy that it really needs and that it really is entitled to if its case is correct. It's also in the interest of legal certainty that parties understand that whilst the discretion is wide, it is not open-ended and it's not an entirely open field for the respondent to an injunctive application, that there is some certainty there as to the level of satisfaction that the court will require in order to turn away from enforcing the contract in what I say is the ordinary way.
It's not obvious to me that in paragraph 38, that sentence you rely on, Mr. Justice Senior was doing anything more than saying, on the facts of this case, given that I think that the covenant is likely to be enforceable and that there's prejudice to the claimant, there has to be some good reason to come down on the other side. It's not obvious to me that he was enunciating some general principle applicable to all interlocutory cases.
Well, my lord, in the way that he states it there, in my submission, he clearly considers that it is a strong countervailing reason that is required in order for the balance of convenience to weigh in favour of the respondent. And he goes on, paragraph 39, I do not consider there's a strong countervailing reason or the evidence and arguments before me, and that's exactly the evidence, or exactly the arguments that are made in this case, that continuing remuneration would be at risk. And again, I step into my arguments about the problematic nature of the evidence in front of the learned judge in the current case, because Mr. Justice Saini says at paragraph 40, I do not accept there is a proper evidential foundation for this submission. It's not simply that there should be a foundation, but that it should be proper, it should be sufficient to provide the court with satisfaction in my submission that it amounts to a strong countervailing reason against the award of injunctive relief. And stepping as I have into my submissions in relation to the evidence on hardship, I say that the learned judge in this case erred in what he accepted as sufficient. I've set out in my skeleton the statements that the respondent makes in his witness evidence amount not really to evidence but to speculation of what might happen. There wasn't the quality of evidence that ought to have been provided on lack of availability of jobs, of possible attempts, or evidence as to means and the respondent's resources, of which we know absolutely nothing. In my submission, the court ought, in the face of an application which has ticked through, at that point, 4 stages of tests, the 3 stages of serious issue to be tried, the 4th stage of adequacy of damages, that the court ought to require proper evidential foundation to support a strong countervailing reason, not to order injunctive relief. And to just very briefly, my ground of appeal in relation to the burden of proof, in my submission, essentially by taking the approach that the judge did, by being satisfied with so little evidence, and by fusing his consideration of the hardship factor, that discretionary consideration, at the stage of also considering whether there was a serious issue to be tried, he misplaced the burden of proof and essentially saw it, in my submission, as a matter for the appellant to satisfy the court that the respondent would be able to get further work, would not befall hardship, rather than understanding that he reached the final question, final test to be applied, and seeking to be satisfied by the respondent that his, in my submission, hyperbolic statements, speculative statements, had any truth in them. And on the question of whether this is a strong countervailing reason, it's worth bearing in mind the government consultation at the moment about whether non-compete covenants ought to be enforceable only if there's payment during or for the period of restraint. The automatic, or well, very often the corollary of the enforcement of a non-compete covenant is that the ex-employee cannot perform a particular role, and it may well be, in many cases, that they cannot perform the role that they have moved into. So some element of financial disruption may well exist in the ordinary course, but that's not a bar to the enforcement of non-compete. It's not a bar to their enforceability under the Herbert Morrison Saxby formulation, nor is it a bar to the award of injunctive relief at the balance of convenience stage. It's a part of the territory. Those are my submissions in relation to the hardship point. If I can turn then to the question of my 10th ground of appeal, which is the disclosure of the contract. It's a short point. Part of the application was for disclosure of the respondent's contracts of employment with ServiceNow. The judge hasn't discussed that in the judgment. However, the order that he makes removes that. He declined to order that part of the relief. And I say simply that in a case where the job that the respondent was able to do, the job that he was doing, whether or not he would be able to continue that, whether he would fall into hardship or not, was so central to the issues under consideration that disclosure of that document ought to have been ordered at the interim stage in order for the court and the appellant to understand the reality of the position, the reality of the submissions that the respondent made.
Didn't the judge's clerk deal with that in an email after the judgment? The thing I've seen somewhere in the papers, an email that was sent after the judgment by the judge's clerk, and effectively what he said was, don't want to order it without having heard.
Tab 5, core bundle.
Yeah, don't want to order it without having heard from the new employer.
My lady, yes. That was the, I'm grateful, that was the principal concern of the judge, that this was a confidential document as between ServiceNow and the respondent. But in my submission, that was an irrelevant factor, because the power of the court to order disclosure and the relevant ambit of disclosure is that which is relevant. Confidentiality considerations can be dealt with in any number of ways. There was already a confidential bundle before the court in this case, and redactions from the contract would have been possible. So in my submission, I nevertheless say that the learned judge erred in not ordering the disclosure of the contract.
I haven't quite understood this. By this stage, you've had your argument for an injunction and it's been refused. The next stage is trial. You will get disclosure for trial. What purpose does it serve once you've lost your injunction to see his contract before it's disclosed in the normal course of disclosure?
The purpose it serves is to understand the reality of the submissions that have been made at that stage.
But you're not going to make another application for an injunction, are you? On the back of the contract? If you've seen the contract, you wouldn't...
Well, we don't know what the contract says. We don't know what the scope of duties is. We don't know whether the reality...
I understand you want to know what he's doing for your competitor, but I don't understand how it fits into a litigation process. You've made your application for interlocutory injunction, you've failed. The next thing you have to do is prepare for trial. You will get the contract. You will have it for trial. Why does getting it early help the litigation process in any sense at all, unless you think that it might give you an opportunity to argue again that you should have an injunction, which seems to me quite far-fetched.
It would, if the contract was not as the respondent has presented, provide an opportunity for there to be discussion between the parties in correspondence as to the progress of the case. But my submission, in essence, is that if statements are made at the injunctive stage and there are documents that will prove or disprove those statements, they ought, in the ordinary course, to be disclosed at that stage. It oughtn't to be that a partial position can be presented.
You're quite entitled to submit as you have. We don't really know what he's doing. Clauses 17.1c and 17.2c taken together on their proper construction only restrict him from facilities management software. He's free to work even for ServiceNow, provided he has nothing to do with facilities management software. Why do you need to see the contract?
In order, as I've said, in order to understand whether the position is that which he presented.
But you don't normally get disclosure from a defendant when you've had an interlocutory battle and lost it, in order to check whether he perjured himself in that process. I mean, there are exceptional cases like Moravas and so on, where you need to carry on policing an injunction, where the court will grant interlocutory disclosure, particularly if it thinks that the defendant has been misbehaving. But in this case, simply saying we want to know whether what he said to the court was right or not doesn't seem to me to be a good enough ground to get early disclosure. As I say, you'll get disclosure before trial. At trial, if it turns out that he's been telling you a pack of lies, you can cross-examine him along that basis. I don't see why that entitles you to see something early in the litigation.
Well, my lords, on disposal, I invite you to vary the order of the judge and uphold the non-compete and enforce it. And so, in essence, I invite the court to undertake a like exercise as undertaken below. And in the course of the court's discussions, I've made submissions about the adequacy of protection. I've made submissions about the lack of evidence as to hardship. And this is part of the piece. It is being said, I anticipate it's being said by the respondent, if I can't do the duties that are prohibited under clause 17.1c and 17.2, then I can't carry out this role. But at the same time, the respondent refuses to tell us, to show us the documents that will tell us what that role is.
But you've made that point.
That's
yes.
my submission, my lord.
All right.
But I mean, isn't the position really that the court would be entitled to draw an inference from the non-disclosure of the contract? But because if he's been asked for it and he hasn't disclosed it, the court can draw inferences from that, can't it?
But my lady, it certainly can, and that's part of the lack of a proper evidential basis for hardship and for any exercise of discretion against the appellant and in the respondent's favour. My lords, I've come to the end of my submissions, apart from the question of delay.
Yes. Now, on that, your clients found out on the 2nd of December that he had, 2nd of September, he'd started the previous day with ServiceNow, and he'd been evasive about where he was going before then. There's then some perfectly, if I may say so, civilised and sensible party-and-party correspondence up to the 24th of September, and then nothing happens at all for 3 weeks. That's very odd.
Well, my lord, this is addressed. You've got the further bundle and the witness statement within that, at page 17 onwards of Matthew Grant of my instructing solicitors, and he, in that statement, sets out a little more in terms of the activity. At paragraphs 4 and 5 of that statement, 5 in particular, the attempts to resolve without issuing proceedings. Correspondence continued until 29th of September, he says, at which point it became apparent that an agreement could not be reached. And then discusses the normal processes that had to be gone through in order to prepare the application. And the application was issued on the 22nd of October, so inside a month from the point that it was apparent that an agreement could not be reached. Mr. Camps, in his evidence, his witness statement, and it's paragraphs 66 to 69 of the statement in particular. This is in the supplementary bundle at tab 3. Discusses the correspondence starting on the 20th of September and then says at paragraph 69 there was a short period of time before receiving board approval to proceed further, and of course that's board approval from the parent company in Holland. There were various processes that had to be undertaken, taking of legal advice, the internal considerations, and in my submission it is an unremarkable period of time that's passed between the critical point, understanding that a non-court resolution was not reasonably possible, that an agreement could not be reached, and that recourse to court would be necessary, to then undertake the work that was needed to be done in order to prepare the application. And in my submission, the court ought not to be too hard in assessing whether or not there's delay, because of course there is, on the other hand, jeopardy for an applicant in not getting their application right. And that's a jeopardy that hurts the applicant, the defendant, one way or another, even if there's compensation in costs. Also, of course, hurts the court, because it drains the court's resources if applications are made too hastily, without being properly considered, without being properly evidenced. And you'll see I've cited as one of the authorities the Pathology Group and Reynolds case, another decision of Honour Judge Seymour, where he punishes in costs the quick and aggressive move in that case to injunctive application. And part of his criticism is that because it was so quick, the proper defendant wasn't properly considered. Who is the target of this injunction? And he chides the claimants, as he says quite colourfully, it's in paragraph 30 of his decision, that they have gone in hot and strong to put the case as high as it could possibly be put. It oughtn't to be. Delay is a real factor. I entirely accept that. It's a real factor for the court to have in mind, and will justify the exercise of discretion in an appropriate case against the granting of relief. But on the other hand, a court oughtn't to be too harsh that litigants are then forced to make decisions to go in hot and strong, where reflection would produce a more happy resolution.
Yes.
Delay, as I've set out in my short additional skeleton on delay, if delay is fairly well explained, then it oughtn't to be taken against the applicant to an injunction. And just as a final point, it was only on the 18th of October, shortly before the application was in fact submitted to the court, that there was evidence about a customer, potential evidence about a customer migrating to ServiceNow.
Something about a booking desk module, whatever that may be. All right.
That doesn't seem to be an existing customer, but a prospective customer.
I think that may be right.
That's quite significant.
Well, my point on this is that there wasn't until that stage evidence of other breaches than the move to ServiceNow, or evidence of potential other breaches than the move to ServiceNow.
Is it a breach to solicit the custom of someone who was a prospect but was not actually?
Yes, I think that is covered in the.
That is covered, is it? Thank you.
Forgive me. I'm so sorry. I'm told they are an existing customer.
Right.
But in any event, if they were a prospective customer, then that would likely fall foul of the potential misuse of confidential information. My lords, unless I can assist you further, those are my submissions.
Thank you very much, Mr. Shepherd.
May it please your lordship, ladies. I note the time, but we have, I think, 20 minutes or so.
Give us a flavour of what's to come.
Of course, I'll endeavour to so do. A couple of points at the outset, if I may, quite, not specifically in relation to the law, but generally in relation to this case. It's right to say that the judge below, Mr. Justice Edwin Johnson, is experienced in these areas. You see that I pray and aid the case of Re-C adoption proceedings, and there's a presumption, because what we're looking at here is whether or not the judge made an error or errors of law. We're not looking at what the claimant might have wanted by way of an outcome in relation to the non-compete issue. And what I do submit at the outset is you're dealing with a judge who's experienced in this area. You also have, at the time that you're looking at it, an affidavit from the respondent, which has not been referred to, but which was entered into and sworn as part of a series of undertakings that he already entered into or had made clear he was prepared to enter into before the interim hearing was determined. So a judge with experience, a respondent saying, you are and can have all of the restraints that you're looking for, including an affidavit which demonstrates that there has, as best as I can say, or anyone can say at this moment, been no breach of confidentiality, no taking of any confidential information. Unfortunately, that affidavit is not before you. I can produce it, but I can assist in this regard in terms of its content. If I might direct the court to the order, it's core bundle at page 36, the order of the learned judge below. And it is useful to go through and have in mind what was the position. It's tab 4 core bundle, beginning at page 36. Before anyone made any argument before the learned judge below. Firstly, the respondent was prepared to, and indeed offered, to enter into the relief in respect of confidential information. Again, in relation to the post-termination restrictions, which are set out at the bottom of 37, in relation to clauses A, B, and D. So everything other than the non-compete. And then he also undertook to provide the information, which we see at page 39. And you get a sense, indeed, I think it's almost, I don't want to get ahead of myself, but exactly mirrored the affidavit, which I can distribute in due course. I think we have copies in the court. But you'll see what he set out, what he has sworn to, is the confidential information he had in his possession for control, location of any confidential information. All of that has already been provided by way of an affidavit. Now, other than the non-compete, the only thing that was sought by this claimant, which you will have seen from the evidence, is very concerned with ServiceNow, perhaps treading on its toes in Europe. But the only thing beyond that was not provided was the employment contract and I think a job description. But it wasn't dealing with that short ground 10. There was no refusal, and it's paragraph 6 at page 40. There was no refusal to provide it. The judge decided and gave the claimant liberty to apply, again, afresh, because the judge was concerned about the third-party interests of ServiceNow and potential confidentiality there. Now, I say that that is, on the face of it, a relevant consideration. But it wasn't a case that the respondent was wholly refusing. The decision was made and influenced by the third-party interests of ServiceNow, but there wasn't a flat refusal. So before we get before Mr. Justice Edwin Johnson, the claimant has everything that it sought and a formal offer to that effect. Yes, the night before, but it happens in these cases. Everything but, in effect, the non-compete, okay, to be complete, the contract and the job description. Beyond that, it had been conceded formally that there were legitimate interests of the claimant. That wasn't really an issue. It didn't need to be hived off into a particular part of the judgment, although you'll see from my skeleton argument that the learned judge did address it. But those legitimate interests, of course, are also evident on the face of the contract itself. They are spelt out, confidential information, trade connection, etc. So one can get them from the contract, in this case that was spelt out. You had a concession, the judge below. There's no real issue on that legitimate interest. So before we start, really, there's very little to argue about, other than whether the non-compete clause, in addition to everything that had already been, if you like, acceded to, was a step too far. And I don't say, and I haven't said, that the Stenhouse case, yes, perhaps I was citing a policy, but one is looking at, yes, the TFS and derivatives case, to respond to my, to your lordship, Mr. Nugee's point earlier. The framework was not simple American cyanamide and ethicon. There was the Lansing Lind element, and then on top of that, the derivatives. There was no final decision made here, as the judge made plain, and of course there wasn't, because the expectation was all along that there would be a final trial. But in terms of the nub of what was looking at and what was to be looked at, in short, what I do say is that the judge properly analysed, and the claimant doesn't like the fact that perhaps he referred in paragraphs 27 and 28, and indeed 26, to the respondent and the impact on the respondent. It wasn't in financial terms. The focus was whether he would lose his job, with the impact that it would have on his family, mortgages, other matters, self-evident matters perhaps. But the claimant doesn't like the fact that there was analysis. But the law is, you're looking at whether they're legitimate interests, and you're looking at whether or not a particular covenant, in this case non-compete, went further than was adequate to protect those legitimate interests. But it necessitates an analysis of the impact on the employee. Of course it does, because there is a balance, and that's there writ large throughout the authorities. And that's what the judge did. And that's what is plain in the structure of his judgment that he is doing at paragraphs 27 and 28. But very importantly at 28, and I pick up on the Harkis Sinclair LLP case, he was entitled to look at the position in the present to see what was in the intention of the parties back when the contract was entered into. And there were 2 dates. I have to say the judge didn't give a definitive view on it. One's either looking at 2015 or one is looking at when the amending agreement was entered into, which was May or so of 2020. However, what the judge made clear, insofar as it's contended that he made an error at paragraph 28, he brought everything back together and he said, looking at this question, i.e. looking at the time that the parties entered into the contract, did this restriction, did this restraint go further than was adequate to protect those legitimate interests? So he applied the law at the right time when he drew his analysis together. So he didn't commit an error law, in my respectful submission, but he reached fundamentally a conclusion that was open to him on the facts of the case, because there was the evidence of the impact on the respondent from the respondent himself in both of the witness statements. There was the evidence of Mr. Camps about, and really submission through evidence, that he could work for anywhere else in the software market, such like. But very importantly, and a point that hasn't been raised thus far before you, It is the effect of the covenants. Looking at 17.1c, 17.2c, 17.2b, they strictly limit what my client can do. Having worked for 6.5 years in a niche area of the software market, and incidentally not having sold software before, and indeed, I might just raise it now, but the software is highly specialised. It covers lease accounting, sustainability management, real estate portfolio management. So it does is how we control offices and spaces. So yes, universities, hospitals, and such like. But it is a niche area. He'd been working in for 6.5 years, not sold before. And if you look and I say correctly construed at the covenant in play, the non-compete, with the carve-out clauses, it is a conclusion that in effect he would lose his job, or it would be, and this is what the judge decided, highly likely, or worse to that effect, outcome. Didn't say definitively. Again, when he brought his analysis back together, that was his conclusion. So on that fundamental argument, because what's prayed in aid is somehow the analysis has vitiated the whole process. I say, no, that isn't the case. The judge was, as Harker Sinclair sets out, you've been taken to the reference already, he was looking at the impact in the present. He'd already taken on board the impact on the claimant. It was taken as read that the claimant had legitimate interest. And it was a fact that the claimant had already, because my client had acceded to it, all of the other restrictive covenants and the provision of confidential, the affidavit, and abiding by confidentiality clause. That was all in place. So the question is, did this non-compete go further than was adequate in those circumstances to protect the interests of the claimant? I say, as a matter of construction, and based on the evidence, of course that was a conclusion that the judge below could reach. Based on a proper application of the law and based on the limited evidence before him, because that's the nature of these interim applications. Now, I don't have a clock behind me.
If you've reached, as it were, the end of a paragraph, we can stop there.
Yes, I think that's the appropriate juncture.
Yes. Thank you. 2 o'clock.